I just pressed the let's go live button, and so let's wait for the stream to fire up all across the fruited plain of the interwebs. Before we go ahead and get started, got to make sure those tubes connect themselves. It looks like we're live on Locals. Our friends on Rumble are hopefully booting up. We got YouTube's firing away. And we're alive and well. That's tremendous. Let's go ahead and get started, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney. And today, we're talking about Donald Trump crushing it at the Supreme Court. If you missed it this morning, we were there and we covered the full thing in detail. And we're going to hit the highlights today, but we're going to hit them at the end of the show. So if you were with us this morning and you don't want to hit the highlights, don't worry about it. We're going to cover some new stuff, and then we're going to get to what happened at the Supreme Court. And so for our final segment today, we've got all of the highlights. If you missed it today, it was a doozy. Trump did very well. The reception on this, even on MSNBC, I've got a couple clips from them. They're saying, oosh, yeah, looks like Trump's going to probably be on the ballot there in Colorado and the rest of the country, because even the lefty judges like Ketanji and judges like Judge Kagan, they were asking very good questions. We're going, wow, it actually sounded like a lot of the stuff we've been saying here for the last 2 months, wondering why wouldn't they put the word president in there if they said that president mattered? Why should one state get to decide the entire country's elections by creating one precedent and then using collateral estoppel preclusion to then spread their disgusting opinions around to the rest of the country? So we're going to see what they said. And there were some really great lines of questioning. Kavanaugh was here. Roberts was here. We've got Thomas and we've got Gorsuch. All the highlights coming up. It was a historic day. And then we want to hear from you. What do you think? What is the breakdown going to be? We had a great discussion about this. Again, we covered the full thing live. It's like 3 hours this morning. And so we want to hear from you. Do you think this is going to be a 6-3, split opinion? Do you think it's going to be an 8-1? Are we going to have a Sotomayor running around out there? Or is it going to be a 9-0? Unanimous in favor of Trump. We'll see what you say about it. All in the third segment. But we're going to start the day off talking about Fani and quashing that Fani, baby. Quash it. So here is what is happening in Georgia. They filed a motion to quash all of the subpoenas, right? So we've got a hearing coming up the day after Valentine's Day. Nathan Wade, Fani Willis, the affair saga from Fulton County that's captivating the nation. This is going to be something we're going to hear hopefully in court, but Fani says, I don't want to be there to testify about any of this. So she filed a motion to quash all of this, and we'll read through it. We'll see what she says. Then we're going to turn our attention over to Jeffrey Clarke. You know him. He's been the subject of a lot of litigation in this country, and he is now joining and filing to also disqualify and dismiss Fani Willis from the Fulton County case. He's been charged as a co-defendant, and he put together a nice brief here, basically saying, she's lying about a bunch of additional stuff, right? She put out the affidavit. Her county, Fulton County, said that, there's much ado about nothing here. This is a bunch of MAGA, salacious, racists who are trying to deviate a powerful black woman in Fulton. And we're saying, well, that's not really, what you're allowed to say and do as the prosecutor. And he's joining, saying that was totally inappropriate, totally biased. You got to go, and you are disqualified. So we'll see what all of that is about and more. And if you missed it, man, fresh out of the oven, we don't have it here today, but apparently our president is as demented as we all thought he was. So apparently they're not going to be charging him with his classified documents problem. So we're going to talk about that tomorrow. I think that's just breaking right now. It's a huge monster, 300 plus page document, I believe, that is from the special counsel, Robert Hur. And so that's happening right now. And we'll come back. We'll take a look at that tomorrow. We'll also probably hit the highlights on that tomorrow morning at watchingthewatchers.locals.com, which is our members only community where we do streams in the morning. We do Saturday streams, and we'd love to have you join us. We got a great community over there. We do, a lot of fun after parties here, and it's just a good time. So come and join us, watchingthewatchers.locals.com, if you're looking for a little extra content and a little extra community. Amazing community. We also have our website. So any PDF that you want to grab, They're all available, robertgovea.com. We also turn every single segment into a report, so you can just read through the summary of what was in the video if you don't have time to watch the full thing. So you can share those with your friends, your family. You can also grab something from the shop, grab a hat, grab a shirt, support the work that we do here, and look great while you're doing it. And of course, our newest community, our newest project for our community is the Watcher Lodge, watcherlodge.com, which is where we're focusing on sovereignty and self-development. And we just this week on Wednesday, we just did the workshop called Building Your Survival Squad. And I want to invite you to go sign up for it now because I'm going to throw it behind the paywall. But if you it's free right now. So if you just go, register for the thing, sign up for it, and get access to it, you'll keep that when I put it behind the paywall. So I'm encouraging you to go get it if you want it. Even if you don't have time to watch the full thing, just go check it out. It's watcherlodge.com. And when you go over there, this is what it's going to look like. This is the actual, so go to Watcher Lodge, and this is what the back end looks like. So click this Survival Squad and EMP, and then you're going to get the actual course that looks like this. And when you pull the course open, it's Building Your Survival Squad. The template is right here. The full chat is right here. People are already dropping some good comments and good stuff, and it's all right there. So watcherlodge.com. Also, don't forget to check out the community calendar. This Saturday, if you want to register and join us, there's going to be 70 people joining us so far to do our unboxing of the SDS scanner, and that's this bad boy right here. So I can't wait to dig into it. It's going to be a lot of fun, and it's a monster. So we're going to look through that. I really don't know much about it, but we're going to learn together when we unbox this monster scanner so we can watch the watchers over the airwaves here offline as well. All right, so watcherlodge.com. We got a lot of fun stuff cooking, and so thanks for signing up and joining us over there at watcherlodge.com. Links in the description below. All right, now let's get to it, my friends, because it's Fani time. Great. Quash that subpoena, Fani. Some people might say Fani's got to quash it. She filed a motion to do just that, and we're going to go through it. She does not want to testify. She does not want Fulton County to testify. We know that she's in a little hot water over Nathan's hot dog, and this is scheduled for an evidentiary hearing in front of Judge McAfee in Georgia, in Fulton County, the day after Valentine's Day. And so we don't know if they're going to be coming from their safe house, bang house, wherever they're coming from that they were all paying for on Fulton County taxpayer dollars. But she's working real hard to not testify. And she's also getting some criticism from some more citizens out there in Fulton County. And we're going to hear what this woman had to say. So this is the motion. Fulton County, Fani says, quash it, baby. Filed in the state of Georgia versus Donald Trump and all of the other co-defendants. Here is Fani's motion. She says, Fani's here to quash it, the subpoena that came from Michael Roman. Roman filed the original motion, blowing the lid off this whole thing, saying, we busted you two. And so then sent a bunch of additional motions and subpoenas, and I think they're attached at the end of this document. But here's what Fani's office says. Says, this defendant, Michael Roman, Fani's writing, has taken the extraordinary step of attempting to subpoena numerous members of the Fani office to a February 15th hearing. Extraordinary, in support of his ill-conceived motion to dismiss and to disqualify Fani. Now, the effort, says Fani's office, should be promptly brought to a close, saying Georgia law, as well as authority from across the country, predictably frowns on a process that permits counsel for one litigant to compel the testimony of counsel and employees of the opposing party. Well, I think that's probably true. Yeah, I mean, we do frown upon, like, nobody wants to be subpoenaing the other party. But when you're banging your special prosecutor, you're kind of out of options, you know what I mean? And there is no justification, she says, to depart from that general principle here. I just named one. First of all, it's your special counsel, and you've got a lot of money problems with paying him what some estimates are about $1 million for that while you're going on cruises and other things. Pay for prosecution. You're getting a benefit from that prosecution of Trump. If Nathan Wade dismissed the case, he wouldn't get paid anymore. You'd have no more cruise money. So that's why we got to do it. No one's happy about it, but that's why we're here. Now, as there is no factual basis, she says, and I just listed it, and I'm trying not to repeat myself too many times here, that could reasonably justify requiring opposing counsel and other employees to be a witness in this case, The state respectfully requests that the court quash each of the subpoenas that are served on the following people associated with Fani's office. So let's just, of course, back that up. What is she talking about here? There is no factual basis that could reasonably... Yes, there is. Okay, first of all, you laid out your position on this in your affidavit from Nathan Wade. Fulton County signed off on that. Nathan said, I don't need to testify. We don't need to have a hearing. Don't call Fani into the stand, because Nathan signed this document, and that's the truth. We said, okay, well, there's a bunch of things in here that we think are lies. He said he met you after a certain date and time. We've got witnesses who says you two were sucking face at the bar at the municipal conference in 2019, okay, with your gavels and your robes on. Weird, but you do you. So that is evidence that we want to ask about. That's why we deviate from the prior general principle, Fani, because there are some lies that are emanating from your office. You allege this. We've got witnesses to say the other. So how about we have an evidentiary hearing? Guess what? We're going to need you at the evidentiary hearing. Here's your subpoena. Enjoy. So she says, they can't fathom that, but here, they don't want the subpoenas to go out to any of these people. And I am so happy that Ashley Merchant subpoenaed everybody, including Nathan Wade. I'm looking at, all right. So District Attorney Fani Willis got a subpoena. She got a subpoena. And hopefully it's served. And she shows up to testify because we want to see it. We also have another executive DA, Daisha Young, Sonia Allen, other DAs, Dexter Bond. Not sure who these people are, but guess who this one is? We know him. Nathan Wade got a subpoena. Michael Hill got a subpoena. We got Tia Green, Capers Green, all got subpoenas in the house, along with Thomas Ricks. Now, additionally, Michael Roman has attempted to subpoena an attorney who also represented Nathan Wade, which is an attorney, Terrence Bradley. So she's going after everybody. I like to talk to everybody you know, your friends, everyone you ever met. You had coffee with them. I want to talk to them. In addition to personal and business bank records also belonging to Wade and his law practice. Now, they're unhappy about that. Thomas Ricks, they say, neither Chief Investigator Thomas Ricks nor Special Prosecutor Wade have actually been served with a subpoena, right? So now they're fighting service. Oh, it's fun. Oh, it's fun. Prosecutors are fighting service. Nuh-uh, you didn't serve me appropriately. Nuh-uh. And this motion to quash, and normally it's reversed. This is why it's so fun. It's like Schadenfreude. It's the opposite. It's like, normally they're having to serve people and drag their butts to court. And now Nathan Wade is like tap dancing around. He's like, is there a process server around here? Going from his $600,000 car into his, into his new bang house, running around. Nope, didn't serve me. Nope. No, Nathan who? I don't know who you're talking about. No, they don't live here. 24 is the rule. They say in this motion to quash specifically does not waive either's rights to raise or lack of improper service. So, you haven't served us, so we're not showing up. Now, both, however, were included on Roman's witness list, and for efficiency's sake, they are addressed in the state's motion to quash. It's perfect. So now, upon information and belief, they say, this is Fani, Michael Roman has not spoken to any, right? Fani's saying he's never talked to anybody, any of the above named witnesses, and cannot with any accuracy or good faith relay to the court the content of their anticipated testimony, right? So she's like, they're my employees, not yours. He doesn't know what they're going to say, so they don't have anything useful to say, and he's never talked to them. So instead, each of these subpoenas are transparently appear to be attempting to conduct discovery, rather belatedly, of an effort to support reckless accusations made in prior court filings, saying the subpoenas should be quashed. They don't know anything about these people, so they don't have a basis to call them in. Saying, we got a lot of rules here, says subpoenas to DAs and to the special counsel. Says, the spectacle of one party attempting to call opposing counsel to the stand has been predictably criticized by the appellate courts. And I would agree with that. Like, all that's true. Like, you don't want a justice system where everybody's subpoenaing each other's lawyers. Oh, you're going to ignore my phone call? All right, subpoena. I sent you an email yesterday, not getting a response, subpoena. Oh, you cut me off in the parking lot on the way to court, subpoena. We don't you don't want that, right? Between lawyers, because we're psychopaths and we'll do it. Like, all right, here you go. But when you have a special situation like this, where you have a prosecutor, right, in a position of power who has allegedly been violating the literal ethical rules of the state and violating the law, arguably maybe the criminal laws, by fraudulently passing money off to her special prosecutor lover, then this is a different situation, right? Appellate courts also, by the way, they don't really like that either, when you have total corruption within a prosecutor's office. They don't like that either. Why don't you copy and paste some of the case law for that? But they say this case is no different. Says you should quash these subpoenas. Courts regularly quash subpoenas. They do it all the time. They only will allow subpoenas of the opposing party in rare circumstances. And they give some examples of those. Any subpoena for testimony or documents that's directed to us is a very high hurdle, Judge. And so don't let them do that here. Mike Roman, the defendant, has not made that showing that we deserve to be subpoenaed. Saying also federal courts, right, another analogy, they try to discourage the gamemanship of throwing subpoenas at each other. Now, federal rules do not explicitly forbid it. They have held that depositions that are trying to harass the attorneys are not allowed, obviously. Like, again, this is like basic law stuff. These people are, a lot of the time they don't really have much argument on this one, I suppose. So here, let's see. Finally, the indiscriminate breadth with which Roman has sought to source testimony from the DA's employees, from Fani's employees, is troubling. Says it suggests an eye towards public narrative as opposed to legal remedy. I don't agree with that at all. I mean, the public narrative is writing itself. What this is about getting to the facts. In your affidavit, which was probably a foolish thing, right, that you did, you said a bunch of stuff, and there are allegations to the contrary about those things. And so that's why the subpoenas are necessary, to clarify what you said, that apparently there's evidence to the contrary about. So they say, in addition to the attorneys and the investigators tasked with investigating and prosecuting the case against Roman, who appear on his subpoena list, other DA staff with no knowledge of the issues have also gotten subpoenas, right? She's blanketing the office, including Fani Willis's executive assistant. She even got a subpoena. Did you schedule those cruises? Look at me. You're under oath. Did you ask for upgrades? What did Fani say about her little cocktails? What time does she have those? 6 p.m. delivered to her room? Did you schedule those? Investigators involved in her security detail, which I wonder if she was using, well, I was going to say maybe the same company as Cori Bush, but personnel responsible for general operations as well. So everybody in Fani's life, her gardener, got a subpoena. Was she here on this date, or did she go to the cruise with Nathan Wade? Defendant has not demonstrated any need for these witnesses, let alone clear the compelling need hurdle, nor can he represent what relevant testimony these witnesses may possess, as his attorney has not spoken to any of them, saying this is just harassment and disruption. Well, we have a pretty good idea of what they are going to say. So I think they're going to go through the various subpoenas. They're saying, okay, so this one went to another attorney. They're saying Mike Roman went after Nathan Wade's divorce lawyer, right? This guy used to work for Nathan Wade. Now, Bradley's a former business partner of Wade, but also represented Wade in his divorce. So any information that he has, they say, is irrelevant. It's protected by attorney-client privilege. It is non-discoverable, and so you can't talk about Terrence Bradley and Nathan Wade. They give us some case law here. They go through the other subpoena. This one, Sinvu Bank. Now, there's a bank to produce Wade's financial records. Sinvu Bank, right? And they wanted everything from that. Application for credit from 2020 to present, credit reports. They say, oh no, you can't get his Nathan Wade's financial documents. This is a fishing expedition. And it's oppressive and unreasonable. And Georgia has said that you can't allow this. So general subpoenas that seek categories of documents are overbroad. This is just generic fishing expedition crap. Any defense attorney in any state will just say, oh, gosh, fishing expedition. Got it. Okay. This is prosecutors like, default NPC language, right? And they're like, well, you don't deserve that. It's a fishing expedition. There's a bunch of case law that supports that. They're like, okay, thanks. And they copy and paste it all the time. So they say, in short, Roman, he's casting as wide a net as possible in hopes that he finds some information to support allegations he's already made. It's a misuse of the subpoena power, and it should be quashed. Now, although litigation is certainly adversarial, they say, there are rules in play that govern the proceedings. Does it also cover like speaking in churches, ranting about racist defendants and their lawyers for 30 minutes on MLK Day in front of an entire church spread around the entire country, and then blaming everybody else for your affair with Nathan Wade? Huh. I wonder if that matters in that at all, or any of the other conflicts of interest that have been made evident in this case. But now, because Roman cannot establish the necessity of any of the testimony or any of the documents, Fani says the subpoena should be quashed. Quash that, Fani. Says this one was signed by Anna Greencross, the white woman with whom Fani did not sleep with, as far as we know. There was no sleeping here, no affair with this one, but only Nathan Wade. So this is what was sent in, certificate of service and all the other things. I think we got some subpoenas here. Yeah, so defendant Michael Roman's return of subpoenas. And this is from Ashley Merchant, the attorney who blew the lid on this whole thing right off. Shout out to Ashley Merchant. And let's see what else is here. Yeah, here is the subpoena that they ultimately got. Okay, Sonia Allen got this, Fulton County DA's office. Hey, you're hereby commanded to appear the day after Valentine's Day in the Michael Roman case. Subpoena signed off here by the clerk of the Superior Court, Ashley Merchant. Boom. Sign off on it. You're done. This one went to Christopher Campbell, business partner of Nathan Wade. Dexter Bond got one. Come on, where's Fani's? There it is. Oh, hey, Fani. Fani got a subpoena right here. Hey, Fani, you're commanded. You better lay aside all of your other business, like letting your county turn to garbage. You be and appear in front of the Superior County Court in Fulton on February 15th. You are required to attend from day to day and from time to time until the matter is disposed of. Get your butt in here, Fani. And I'm sure this felt so fun for Ashley Merchant. All right, for all our litigators out there, come on. You go out there and you sign off on this to go after the Fulton County DA? That's great, man. It's great. It's a lot of fun. So, all right, Nathan Wade got his too. Boom, there it is, right? Same thing. You better show up at the same date and time, Ashley Merchant. And this stuff was served, it says. Well, this guy says, I served Nathan Wade. I thought they said they didn't serve him. Huh. Oh, by certified mail. Oh, you see this? So they're dodging service. All right, so look. This is the return of service notice by the process server. Attorney served by Ashley Merchant attorney. So she says that she did it by certified mail, right? So different service rules, different states have different rules. So she says maybe didn't try to personally serve him, but did it by certified mail. And oftentimes, for example, you can do certified mail and then maybe tape a copy to their residence. So, it's called alternative service. Arizona does it. We've got Scottsdale, Arizona that does this even for photo radar tickets. So, they'll do it for alternative service. And it's a mechanism that apparently Fani's saying is not accurate, right? Service is not effectuated. You gotta, you can't do it by mail or whatever her claims are. So we'll see if that gets litigated. A bunch of other subpoenas went out, and these are the attorneys responding. That was Merchant, but attorneys are responding to the subpoenas. And good stuff. Okay, so that hearing is going to be coming up. We cannot wait to cover it. Be sure you're subscribed, my friends, wherever it is you're watching this, because it's going to be a fun one. Now, elsewhere in Fulton County citizens are saying to the city council that, this is not a good situation. Fani should be focused on taking care of her actual job. This is in Fulton County.
Fulton County has a case backlog of more than 20,000. 35% of inmates in Fulton County Jail are still unindicted by the DA, and 25 inmates died there in the last 2 years amid the Trump grand jury. Fani Willis isn't serving this community. She wasn't even before she became absorbed with her own legal problems. No one believes that now amid new lawsuits, congressional investigations, and subpoenas that she will start doing her job. The community deserves a prosecutor whose first priority is public safety and the rule of law, not helping Joe Biden win in 2024.
Boom.
For the good of this state, she must resign. Likewise, Commissioner Natalie Hall just cost taxpayers $902,487. She must resign.
Wow.
If she refuses to resign, please charge the loss to her district constituents.
Shout out to that lady. So shout out to her. She is out there telling them to resign. So it's a big problem. Sounds like just millions of dollars are just flying out everywhere. I don't know how many DAs have different boyfriends, or different Fannies and different positions have different boyfriends. All got to get paid. Cruises are expensive, man. Where are you going to get that cruise money? Gosh, it just doesn't grow on trees. Have you seen inflation, by the way? All right. So quash that Fani subpoena. Fani is going to be challenging this. We're going to see what the judge says. There will be replies to this. Ashley Merchant is not going to be happy about that. And so we'll be taking a look at what the response says when it gets dropped. And hopefully the evidentiary hearing happens on the 15th. We'll be looking forward to seeing you back here when we cover it, my friends. Don't forget to check out the links down in the description. WatcherLodge.com. Sign up for one of our events, all free for the first 48 hours. So make sure you get over there and sign up for it. And we'll see you back here on the next one. All right. All right, we're sticking around with some Fani talk because we got some more exposés coming from Jeffrey Clarke, and you know who he is. Jeffrey Clarke, former DOJ official during the Trump administration, also charged with crimes by Fani Willis, is now exposing more of the Nathan Wade cover-up. And he submitted a motion that we're going to read through that is joining the motion to disqualify her office, the motion to dismiss the case, and he's introducing some new elements to this. He actually did a little bit of a financial calculation, and he's telling us, remember when Fani and Nathan, they said that they split their bills evenly? They're like, split check, please, split check. We'll divide everything equally, and we'll be very, very accountable. Tell our bookkeepers about this as we're ripping off $1 million from Fulton. But he says, all of that is leading to the inevitable conclusion, they've got to go. And so you remember Jeffrey Clarke. He's been in a bunch of other litigation. They're trying to take away his law license. They're really trying to wreck this dude's life because in many ways they say he was a key player in the insurrection ordeal, right? And they want to go after the lawyers even to take him out of contention. But he submitted this filing in Fulton County, and let's dive right into it. State of Georgia versus Jeffrey Clarke, a co-defendant, one of the 19 in the RICO case brought by the biggest Fani in Fulton County, says that we are adopting the other motions. Okay, so new players are entering the game. Michael Roman submitted the first one. President Trump, he jumped into the game. Robert Cheeley, he's jumping in. Now we got Jeffrey Clarke, and he's jumping in. And here's what he tells us. You can see a substantive motion. We'll hit the highlights. He says, all right, Judge McAfee, hearing's coming up any minute now, and says Fani has 3 stark contrasts and conflicts that require a judicial intervention. 3 big problems. Number 1, she has a personal and financial interest of this prosecution because she's got a relationship with Wade. And it's lucrative, and it improperly awarded him contracts to enrich him and thereby, in turn, enrich her. Now, a government official cannot accept gifts from a contractor whose contract she approves, even if they don't have an intimate relationship, even if they're not indicting each other in their safe house. They had a safe house. Now, the second conflict arises from Fani's speech. She went to her church, the Big Bethel AME Church, the pulpit. And she pointed the finger of racism at those who discovered and asserted her conflicts of interest. That's us, they say. Fani's motive in doing so is not merely stoking racial animus against the defense for its own invidious sake and to poison the jury pool corruptly to enhance her odds of getting a conviction and fame and fortune that will bring to her modern America, but also to exploit the racial resentments that exist to get out of her own scandalous predicament in flagrant violation of her professional responsibilities under the Georgia rules. Nicely done. Now, the third conflict, number 3. The third conflict is that in her motion for a protective order, in Mr. Wade's divorce, she exploited the power of her office and she threatened Mrs. Wade, Jocelyn, innocent, with criminal investigation and prosecution, again to solve her own scandalous predicament, again in flagrant violation of her duties under the law. And she did do that. She said, that maybe Mrs. Wade and the lawyers, like Michael Roman's lawyer, Ashley, maybe they were all insurrectionists. I'm not joking. That was in her response. Says maybe they're trying to interfere with the prosecution of Trump, like hinting that, well, I don't even know what this is about. This is harassment. How dare you even question my office? That's how powerful these people are, how egomaniacal they become, how above the law they actually think they are. They're beyond reproach when they lecture all of us about no one being above the law. It's insane. But she did it, and now she's called out on it. Now, these grave conflicts of interest and this misconduct requires her total disqualification. None of this or none of these can be hand-waved by the DA. You can't just poo-poo these off. And all of her subordinates that are arguing that they are just about salacious sexual matters and office romances are irrelevant. None of that is true. That attempt to trivialize these issues should be rejected by this court in firm terms. Saying, in February, on the 2nd, the state responded to the Roman motion and the filings of Trump. And the state, Fani and her office, they said 5 things. They said that DA Willis has no disqualifying conflict of interest, no financial problems, and that there was no personal conflict of interest. They said any criticisms of Mr. Wade's qualifications were unfounded because he was a judge that time, and that DA Willis has not made any public statements, except that church speech, that warrant disqualification. And number 5, that the process by which Fani hired Wade doesn't justify a dismissal. No basis for dismissing him there. They say, well, we're going to take each one of these by turn and show you why they're wrong. Let's explain. Judge McAfee says the state and Fani, they acknowledge, they admit that there was a personal relationship between Willis and Wade. They said it began sometime in 2022. Sometime. That's a pretty broad spectrum there. Now, in this context, personal relationship is a euphemism for the intimate romantic relationship alleged in the Roman motion. We are saying that they are indicting each other, Now, the state does not deny that the DA was receiving personal benefits in the form of lavish travel. Admit that. Not denying that. Got that personal benefit. Also, not denying that the amounts that Mr. Wade was paid under contracts, that the amount was paid under contracts by Fani's office, or that the Board of Commissioners never approved the contracts. Okay, not denying any of that, just impliedly accepting it. Now, instead, the state confirms these facts, and not even implied, and they argue that they do not show any disqualifying conduct, and therefore they do not matter. They say, fine. Well, to rebut the existence of a financial conflict, they give us this evidence. Here's their evidence. Oh, there's no financial problem. It's not a money thing. Don't worry. Here's the state's evidence. They provide very vaguely and very scant evidentiary support. They say that DA Willis, Fani, and Wade's travel expenses were, quote, roughly divided equally between us. Oh, no, there's no conflict here. Put that on no separate checks because we're honest people. Not that would really disqualify anything, but it was even between. They say, okay, well, the only documentation, even if they make that allegation, the only documentation for Fani that she roughly equally divided travel expenses are travel receipts. They got us the receipts. They're Delta Airlines. There's the purchase of 2 tickets for $697 each. And it's on some identified credit card account. We don't even know whose account this is. So if we accept that this was paid for by Willis on some unknown credit card, this is the sum total of documentation that she's provided for her paying for travel. That's it. So $697 times 2 with Mr. Wade. And says this is all that they could gather? Like this is the entire bit of evidence? Like you guys were flying around, you went to Napa Valley, you went on the Caribbean cruise, you went onto a Norwegian cruise. Like these are nice things, man. So what else did you split? You gave us 2 airplane tickets on all your little lavish love affairs? All right. So that's all that the state could marshal. That's everything you could get. You have a team of literally 12 lawyers plus investigators and staff from the period from January 8th, when this original complaint was filed by Mr. Roman. He submitted it a month ago. And between February 2nd, you got 2 airplane tickets? For $1,400? This figure is far less than the documented expenditures by Mr. Wade. For the benefit of Miss Willis, right? He spent a lot more on her. Doesn't seem very, even to us. And it does not even come close to showing that Mr. Wade and his claims that their travel expenses were roughly evenly divided between them. We've got evidence. We've got a bunch of other expenditures from the divorce proceedings, and we know that Nathan Wade was like cashing out, man. He's like, man, just, I got this contract, but, now I got to take her on all these cruises. He's like, it's kind of, Mr. Wade, he's in the middle of divorce litigation, and he was even held in willful contempt for his divorce case. He was concealing his income, which is a dishonest thing, right? A judge said, stop disobeying my orders. Willful contempt of concealing his income from his wife in the divorce proceeding. Now, here's an interesting footnote. They say this legal commentator, this guy called Harry Litman, he's a former U.S. attorney. He yesterday on YouTube, shout out to our friend Harry Litman on YouTube, that he learned that D.A. Willis also received outside legal help. Of course she did, because their office is full of dum-dums. He said that on that YouTube video, probably a good video. Fulton County DA bites back against Trump's weak attack. Maybe he's on the other side. He said the 176-page motion actually got an assist. Says, we don't know. I don't know exactly who it is, but there have been some outside lawyers who've been joining the cause, he says. Everything is so different. We're in a fishbowl. That includes people who want to be helpful if they can. In terms of overall lawyering in this case, this guy says, I also see, I think it's been solid, though. I have from the start, wow, charging it as a RICO has a lot of implications. I care most about the speed. I think it's a big vehicle to try to lumber down the road and also be quick. Okay, so it sounds like this guy's a pro-prosecution guy, saying Fani's bringing in some other people. Now, they say this is wild. All right, so if that guy is saying Fani's bringing in other stuff, such outside assistance makes more remarkable the thin nature of her response to Roman and the motions on the issue of luxury travel. Yeah, which okay. He says, evidently she is drawing for purposes of responding not only on her 12-lawyer team, but also on an unknown number of other outside lawyers scouring records and performing legal research. And this is still all they could come up with is his point. It's like, wow. I wonder what kind of contract she's paying those outside lawyers, and is she sleeping with them? What's Nathan think about that? He's like, hey, baby, who are all these outsiders, man? You got a contract with him? I thought we only had contracts together. Now you have a contract with him too? I thought ours was special. So the court should require D.A. Willis to disclose who has provided that outside help, and maybe whether she's sleeping with them too, my words, I don't know, whether they have taken any oath as a special assistant and how they might be compensated, so that it can be evaluated as a possible improper gift and other ethical standards that bind her. They wanted to write in there, and sleeping with them too. But they didn't write that in there. I'll add that for them. I know that's what they wanted to put in there. I know it, but I'll put it in there. So this is Jeffrey Clarke's motion. We'll help, we'll fill in the gaps for him that they can't put in court filings. We submit as well that the fact that Willis is receiving outside help underscores the political lawfare nature of this prosecution. Yeah, where's it coming from? George Conway's team, particularly Litman's reference to the cause and the need for speed. What cause? It's a political cause. Why the need for speed? Well, because it's an election battle, obviously. So great, footnote there. Now we'll see what the judge does with that, but I think he'll just say, okay, it's a lawyer, whoever he's talking about, I don't know. But it's an interesting footnote. Now on January 8th, Jocelyn Wade, the victim of this affair, home wrecked. Remember, Nathan Wade got the contract with Fani the very next day by Jocelyn, filed for divorce. Signed it with Fani. Woo! Feeling good over here. Oh, sad of divorce over here. Bye. Right? So then Miss Wade served a subpoena on Fani. She said, you got to show up to this divorce. Then Fani filed an emergency motion. She doesn't want to spend any, time testifying there. And then they settled that case because, I think Nathan was like, you can have everything. You can have, whatever you want. Have the car, have the kids, have my future kid, whatever you want. I don't care. Because I cannot have you put my lover on the stand. Oh, so the main thrust of the motion for the protective order is that she's protected by the Apex Doctrine. She says, that the motion, in her motion for a protective order, Fani Willis, the gall, accused Mrs. Wade of obstructing, okay, which is a crime, obstructing and interfering with ongoing criminal prosecutions. Fani uses the power of her office to slam this back on Jocelyn. How dare you demand me be coming to your divorce to testify? Well, I dare because you slept with my husband, apparently, at a 2019 judicial conference, and we're getting divorced now. And apparently, he's hiding funds that you were paying him to the tune of $1 million that are marital assets that are part of the divorce. That's why. She turns around, and I'm telling you, right, these prosecutors in these offices have a ton of power. And this might work if this were not a national case, right? Like if she just sends this letter, this notice, oh, you're coming after me. How about I prosecute you for obstruction, right? Like that's a real threat. Now she made that threat in this filing, and these lawyers are not obviously going to take that. Obstruction and interfering by subpoenaing you. This is you're doing, Fani. You're not above it just because you're biggest Fani and Fulton DA. The DA motion also asked for time within which that she could complete review. And she said the DA wanted to investigate and depose relevant witnesses with regard to the interference and the obstruction motion that this contends. So she's going to open up an investigation against Jocelyn. It's sick. In this filing, Fani crudely exploited the power of her office to threaten Nathan Wade's wife with a criminal investigation and then possibly prosecute her in order to gain personal advantage for herself and her boyfriend in her boyfriend's divorce. It is so unethical. She's going to not only not have to testify, but she'll just put his ex in jail. Don't even need a divorce. Well, just put her in prison. You don't have to pay her alimony, okay? She'll just go to prison. Love you, baby. So Mr. Wade's concealment on an amount of his income in the sworn affidavit also appears to violate Georgia ethical rules, right? Mr. Wade willfully was held in contempt. And these are the people who are prosecuting. Okay, 19 people, -4. The DA's emergency motion brought unfortunate results. Now, the very next day, Mrs. Wade filed a response because they called us, insurrectionists who were interfering with the prosecution. The very next day, Mrs. Wade filed a response. She said, oh, well, this is not obstruction. This is not interference. Why don't you look at the credit card accounts? Here's some actual proof of what we're alleging. There's documentary proof of the allegations. It turns out that Nathan did pay for travel. He went with Fani to Napa Valley, California. He went on cruise lines to the Caribbean resort destinations. Here's a copy of the response attached below. Now, before filing the state's response, then Miss Willis went out to the church. She stood there in front of her congregation to address the controversy. Now, while she did not deny the affair, in fact, she admitted to unspecified imperfections. I'm not perfect, God. She accused her accusers of racism, did it blatantly. Her statement was televised. It became national news. Video clips of her theatrically making the accusations of racism in the form of stentorian church rhetoric, punctuated by supportive murmurs from an amen corner in the church, were in heavy rotation on news sites and networks for several days. Why, God? And then you heard, right in the background. That's what he's talking about. Her waving the bloody shirt of racism. Wow. Fani's waving it in front of her congregation. Served no legitimate law enforcement, no public information purpose, and was intended to whip up invidious racial animus against the defendants. And it was done to deflect the attention from her own misconduct. You're racists. President Trump joined the Roman motion, move for dismissal. And then Fani and her letter to God was read at the Big Bethel Church. And her nakedly unethical threat to criminally investigate and prosecute Wade were grave breaches of her public and professional duties, carried out to serve her personal and romantic interests and those of her boyfriend in this divorce. Now, such grievous misconduct is intolerable in any lawyer, but especially a DA. And even more, especially in this case. Now, they are going to give us some analysis of the records of the finances. They say here, The following data that was taken from Fani's motion summarizes the personal benefits that we know flew and have flowed from Mr. Wade to Fani. Here are the records. Now, apparently, here's the summary of this. The 11/21 transaction date, there's a 1-year contract for professional services. They say apparently this is missing. Nobody can find this. Don't have the 1-year contract. Oops, where'd that go? Here on 3/1/2022, an execution of professional services agreement, which is another exhibit, from 11/21 to 10/31. And then we have some Royal Caribbean stuff. All right, so $2,500 here. 2 Royal Caribbean looks like tickets right there, right? On 10/4. American Airline tickets. We got Nathan Wade, Fani Willis, and Fani Willis. So she flies out from, well, I don't know what, actually that's not a ticket. That's just some sort of a fee. Maybe she bought, I don't know, whatever, insurance or something. So here, right, 2 tickets. That's a ticket, and that's like another maybe insurance. Maybe she can't go. Maybe she has to do some actual work. No, that's probably not true. So $477 a piece on 10/4. All right. Here's more. $61. Freedom of the Sea, Miami, Florida. Hyatt Regency, Aruba. Norwegian Cruise Line, that's a big one, $3,000. You know, Norway, right? That's an expensive one. Execution of professional services agreement, Delta Air for Fani and Nathan, $800 a piece on those. Doubletree, Napa Valley, hanging out, sipping on some wine, and another, okay, $10,000. Now that summary, $10,000 is only what we know so far. And remember, Fani said, no, I paid the $1,400. Remember, she said that in my motion, and she submitted that ticket. She's like, 2 tickets here I paid for, so $1,400. No, and that is Fulton County money, baby. That's Trump prosecution money. That's pay for prosecution money. That money came, you know, if Nathan Wade said, well, sweetheart, this case is kind of insane because there's no evidence in any of it, so we can't prosecute it. Then she's got no cruise money. That $10,000 is gone. So the summary is based on what we know so far. And the total amount that is reasonably attributable, look at this number. Woo! Okay, the total amount reasonably attributable to Miss Willis's direct personal benefit on these statements is $5,000 before the indictment. Now, this amount is 7.8 times greater than the expenses paid by Willis, according to the documents that were attached. So 7.8 times more. Now, Ms. Willis cannot be heard to claim that $5,000 are legally insignificant. No. In fact, the federal bribery statute, oh, love that, 18 U.S. Code 666, where applicable, is for $5,000 or more, the bribery statute. Now, prosecutions over amounts that are comparable are commonplace. $1,500 for a zoning bribe is enough. So $5,000 before the indictment that went over to Fani is enough for federal bribery statutes. And it's a lot more than whatever Fani paid. Okay, so in other words, she got $5,000 of benefits. They look through the same documents and it's like, okay, she got whatever that divided by 7.8 is, right? She paid that amount or whatever. It's a small number. Now, the state's response does not say a word about these expenditures. She got all those benefits. Or there's 7.8x mismatch between the amounts that Fani paid and her sugar daddy paid. Instead, the state pretends that evidence does not exist and says that based on Wade's affidavit, they say to be absolutely clear, this is Fani, the personal relationship between Wade and Fani has never involved direct or indirect financial benefit. And there is no evidence, they say, that Willis derived any benefit from Mr. Wade. But from the evidence that we have right now, that claim is greatly exaggerated, if not flatly untrue. But the state is not content to merely ignore and mischaracterize this evidence. They also present her tribulations in this case as an ersatz ledger of offsetting sorrow by attaching as exhibits examples of profane and racist abuse. And remember, they did that. I almost went scrolling into some of those, and they weren't good, no doubt. And I don't condone or endorse any of that. And a lot of that is just very unwell people. And when you are, it's the law of big numbers, right? If you're going to be in front of 300 million Americans, it's just math, right? There's going to be somebody who's unwell who's probably going to be on the email list sending you something. So I don't condone it if it's actual legitimate threats, right? They investigate that stuff. They even arrest those people and charge them aggressively, by the way, very aggressively. But what the heck does that have to do with these two sleeping with each other and paying him $1 million? What the heck does that have to do with anything? You guys are racist, and I got bad emails. So therefore, I love Nathan Wade. Leave us alone. Here's another $1 million, sweetheart. Love you. The abuse is deplorable, they say. Obviously. Okay, no one condones this. Why are you bringing this up? And Mr. Clarke and his counsel join all moral observers in condemning it, obviously. But they just bring that out. They're like, every time it's like their trump card. They just pull it out. I got attacked on email. Hey, Fani, why did you embezzle $1 million and go to Napa Valley? I got attacked in an email by a racist. All right. Can I talk? No, look. But can I ask you? No, look. All right, jeez. All right, I guess I'll leave. So, but with this argument, Fani is again, she's playing the race card to distract from her own professional misconduct. Now, it is also true that the DA has ridden state versus Trump to national glory. Fani is seeking national adulation in congenial circles, including a hagiographic treatment of her role. Man, this motion has some $3 words in it. Of her role in the case by Michael Isikoff and David Kladman in their new book, Find Me the Votes, a hard-charging Georgia prosecutor, a rogue president, and the plot to steal an election. Oh, man, I'm sure those guys are so mad they worked so hard on that stupid book. Could you imagine being one of those authors and just being like, okay, look, our book's almost ready. How's the cover look? Cover looks great. Looks great. Back from the editor. Okay, we made those changes. It's all great. Perfect. Hard-charging prosecutor. You can say that again, huh? I'm sure she is pretty hard-charging, if you know what I mean. So they go, oh gosh, our whole fake narrative that was going to be like this big book about big Fannies, like, wow, what a queen and hero of America. And they're like, addendum, Fani banged Nathan in a safe house on Fulton County dollars. Footnote 117. It's like, oh gosh, their life's work is ruined. So argument now, prosecutors, obviously, that's the background. So we'll see what's here. Prosecutors have special duties, right? They're not supposed to have any personal or financial interest in a criminal investigation at all. If you do, it conflicts with the Georgia rules of professional conduct. They swear oaths. The Supreme Court says they have high responsibilities. The Georgia rule of professional conduct says if you do anything that is going to materially or adversely affect the representation of a client, that's a problem. If there's any personal interest, you got to go. Now, if the DA is disqualified, if Fani's gone, the entire office is gone. Here's the case law that supports that. She's gone. She's the top Fani. She's gone. She's out. Now, if she is found to have personal or financial interests, the entire indictment must be dismissed. Whew, that's a good one. Now, the court has held in this prior case that a solicitor general's personal interest from a contingent fee, which is not what we're talking about, resulted in that one being dismissed. And here, there is no doubt that in this case, the grand jury issued the indictment long after the personal relationship and the personal benefits began. So they needed the indictment to come back, right? Otherwise, that's the end of the gravy train, man. If Trump's not indicted, they don't have cruise money. So even according to the vague reckoning of when their relationship began in 2022. And so thus, when the case was presented to the grand jury, Fani had a disqualifying both personal and financial interest in the prosecution because she gave her lucrative contracts to her boyfriend, and that contract funded their cruises. Nor did Mr. Clarke have any notice that he would even be included in the indictment. Now, the state says that to be relevant to disqualification, that the personal interest must be in conviction, right? That there's an interest in the actual conviction. That's not the law. That's just them making this up. Their obligation is to do justice. It inheres in everything that they do. So the very beginning, if you've got an interest in the case going to trial to make more money, the conviction is not necessarily relevant. It's like the burden is on the defendant from being prosecuted. Now, the state concedes that a sufficient personal interest warrants a dismissal, but that no sufficient interest has been brought up here, saying the defense in this case did not learn about these benefits until January 8th. That otherwise we would have brought it up earlier, right? But we just learned about it. Now, the interest has been shown, but the argument collapses, right? Fani says, oh, there's no interest here. Like, what are you talking about? Credit card statements are right here. It shows substantial gifts to Willis before at least 2 of Wade's contracts were even executed. You were getting money. Credit card statements summarized above show substantial gifts to Willis before at least 2 of his contracts were executed and before the case was presented to the grand jury. Now, they say there's no prejudice. You know, even if we did all this indicting of each other, there's no prejudice. No one's harmed, right? There's no actual problem here. Like, so what if we're, going on these little safe house retreats with our judicial robes? But it doesn't matter to Trump. They say no. Even it still matters, right? If you have a personal interest, you don't have to have a showing of prejudice, just that there's a conflict, even an appearance of a conflict. Now, they also say Fani violated her duties by making those comments at the church. They serve no legitimate law enforcement at all. They clearly violate Rule 3.8. The obvious purpose of her speech was to deflect from her own criticisms and to attack others. And it served her interest and Wade's interest. It was not being done in the public interest. She wasn't speaking as a prosecutor. She was covering up for her affair. Now, the speech is therefore a paradigmatic example of an actual conflict between their personal interest and their public responsibilities. She chose her personal interest before her professional responsibilities and went to church and lectured her congregation about how she's being victimized. So the state's response misses the point. It missed a lot. Their response was not very good. It first attacks the straw man that the speech is not constitute selective prosecution. And again, we said this when we read the reply, that they're arguing around the point. What are they talking? An argument that was not even made in Trump's motion, right? Didn't even make it. The next straw man that they slain was about a change of venue motion, which we didn't even file yet. Remember, she was like, Trump can't pick his own prosecutors. No defendants can. We say, okay, that's great. No one cares about that. That's not the argument. The argument is Fani's got to go, not that we can go pick someone. Now, they're kind of close, but not the same at all. Now, they sound close, but they're not. Now, the argument actually made by Trump, but studiously ignored, rests on policy interests, right? The rules say extrajudicial comments that might heighten public condemnation of the accused are problematic. So not only you speaking, but will it heighten the public's condemnation of you? Is it going to exacerbate the negativity towards a particular defendant? Guess what? Yeah, the murmurs through the crowd when she said, God, why, God? And the alleged racism of her critics are direct proof of that very condemnation. The rules say no condemnation. Well, you heard it. That murmurs in the crowd saying, yep, and comment that this is literally designed to prevent. It is an unfortunate reality of modern American life that race runs through many public issues and controversies. But in light of this, prosecutors have a special duty not to whip up racial animus, not to whip up resentment against the defendants that they're prosecuting, especially in jurisdictions like Fulton. Now, the DA's, Fani's, her breach of the rules is so flagrant, it's so outrageous that it warrants a dismissal in this case. It warrants a disqualification of her all on its own. It's all the more egregious because she did it to distract the public from her own misconduct. Like, she's not speaking out like fired up on behalf of a victim or something, right? Like, this woman got attacked. Blah, blah. Okay, relax. Like, okay, you get passionate and fired up. She was defending her own bang sessions with Nathan. The entire case is now certainly irreparably tainted, and it is tainted, only worsening the taint of the financial conflicts of interest that existed before the indictment was even handed down. Now, she also violated her code by threatening to prosecute Jocelyn, totally innocent. A more naked threat of criminal prosecution is hard to imagine. says that she put in a public filing, right, in writing, the bravado, brazen filing of interfering and obstructing with a criminal prosecution, right? She said, we need time to go investigate this. It is indisputable that this threat was made not to advance a legitimate law enforcement interest. She wasn't getting interfered with by Jocelyn, but it was to gain an advantage for herself. She was threatening Jocelyn with jail and her boyfriend in her boyfriend's divorce case. Oh, don't worry about it, honey. I'll just threaten her with investigations. It is one thing and a bad thing for a private attorney to violate this rule, but it's a whole nother thing for a Fani to do so, a DA. In this instance, Fani has again breached her professional responsibilities to the people of Fulton County, and it warrants disqualification. Now, she says our contracts were also totally appropriate, but that can't withstand scrutiny. Under the Fulton County Code, the rules say an interest is any financial interest, personal or not. Now, it's undisputed that she has caused substantial funds to be paid to Wade. Regardless of any personal relationship she might have with him, Wade is a prohibited source of gifts. She caused him to get paid. She cannot accept something back, whether they're indicting each other or not. The gifts and favors section that she received from him show that there is an actual conflict. The law says it. Gifts and favors, anything of value given or received from a prohibited source. Someone, we read all this yesterday. Someone who is a prohibited source, somebody doing business with the county or somebody over whom you have authority. Now, the state contends that Ms. Willis has not received any gifts, but the evidence shows otherwise. And so it's clearly enough to show that there was lavish, expensive travel from Wade to Fani that we, of course, have documented. Now, they can't waive this conflict of interest, right? This is not something that anybody can just, write off. And she needed to go take this to the board of directors in order to get this approved. State employees, if she wanted to disclose some of this. And they're talking about the contractual. A lot of this is kind of boring stuff, so we'll fast forward through it. But the county's purchasing code, these are the procedures. This is how you have to award the contracts. Here are the things that Fani violated. Prohibiting employee conflicts while they're contracting. Requiring prompt disclosure of financial interest. Violated that. Violated that one. Prohibiting kickbacks or any other employees involved in procurement. You can't get, kickbacks. Violated that. All of this. She says we weren't required to comply with any of this. But the authority that she cites is bad. Any longtime resident of Atlanta will recall a long parade of local government officials and the contractors who bribed them being packed off to federal prisons, whether the gifts given to Willis by Wade and the sole source no bid contracts, whether they're in the same category remains to be seen. Oh, man. All right, so one more time. Any long-term residents of Atlanta, they'll recall long parade of local government officials and the contractors who bribed them going off in buses to prison. Now, whether the gifts that were given by Willis to Willis by Wade and whether the sole source of the no bid contracts by Fani to Wade are in the same category remains to be seen. You're going to jail. All right, so they say neither the DA nor Mr. Wade disclosed their conflicts. They were required to do that. There's disclosure forms that we've already looked through, and they don't contain a disclosure. And so here, the affidavit also in his divorce did not disclose his compensation. He's been covering this up for a while. He said his income was $14,000 per month. But records from Fulton County say it was $30,000 per month. Why is Nathan Wade being so dishonest? Weird. I wonder if he's being dishonest in his prosecution of the president and 18 other people. Nor did Mr. Wade disclose the source of his compensation from Fulton County. Now, 3 days after the indictment in this case, he was held in willful contempt by the court in his divorce for hiding the income from his wife. Contracts with Mr. Wade by Fani were never submitted to the Board of Commissioners for approval. If she submitted them, they would have never been approved because there would have been conflicts of interest. She never disclosed her conflicts of interest, hiding the gifts that she was receiving from her contractor and her boyfriend. This is just great. And And Ms. Wade did not file his oath until defense counsel raised the issue, right? Covering the whole thing up. I don't know how these people thought they were going to get away with this. It's so brazen. The DA's office and the county have also, it's like they didn't even do anything. Like, you have to fill paperwork out. That's like half the job. And counsel from Judicial Watch, they got records. Shout out to Judicial Watch. And so now they're all filing lawsuits. The totality of the circumstances show that Fani was evading the contracting procedure. Multiple failures. They made multiple misrepresentations under oath. DA and Mr. Wade's dovetailed evasions and omissions benefited them both. It covered up their personal and financial relationship. And it didn't unveil their disqualifying conflicts of interest. This is like bad. And this is crafted like almost like an indictment. You know, it's like, my gosh. The cover-up lasted 2 years, during which the DA paid Mr. Wade over $653,000 and his 2 other former law partners $200,000. The longer the cover-up lasted, the longer the scheme could continue, the more Mr. Wade could be enriched, and the less his divorce would cost him. The enrichment by these methods inured to Fani's personal benefit through their relationship. They traveled together. And although the DA asserted the contrary based on the Wade affidavit that we read here, she has refrained from putting in her own affidavit. There is no Fani affidavit. There is no real, or at least there is scant evidence that they split the cost of the trips, the gifts, or the dates equally. And so in conclusion, Jeffrey Clarke's team says that the DA has Fani has repeatedly lost track of the distinction between public interest and self-interest. She has 3 stark conflicts, and courts must intervene. She's got a personal and financial interest in this. Lucrative and improperly awarded contracts that she benefited from. There is a kickback scheme in action here. And she also gave a speech. She tried to foment racial resentments to get out of her own scandalous predicament in violation of the rules. And third, she threatened Jocelyn Wade, the innocent party and victim of this home-wrecking scandal, with prosecution for daring to pursue her own divorce in a separate divorce proceeding, saying the administration of law, and especially that of criminal law, should be like Caesar's wife, be above suspicion, and should be free from all temptation, bias, or prejudice, so far as it is possible for our courts to accomplish it. But that's not happening here. Fani is afflicted by a veritable compendium of grave conflicts of interest that require disqualification of her and her entire office, and dismissal of the indictment, which has been tainted by her and Nathan Wade's participation in this entire scam from the inception. Signed by Harry McDougald and Catherine Bernard, 2 lawyers out of Georgia. Shout out to Catherine Bernard and Harry McDougald for putting together a very nice motion, almost like an indictment. Quite good. And you can see that Fani is not going to be too happy about having to deal with all of that, because every time we go through this, right, people are putting more pieces of the puzzle together. They're assembling this record. Everybody's digging now. All the defense attorneys are digging. And it's like chum in the water. You know, it's like, let's go get it. So we are very excited to see where this goes. Jeffrey Clarke now joining the other co-defendants in Georgia, and the hearing is going to be scheduled the day after Thanksgiving. So we're going to see if Nathan Wade and Fani Willis are hungover, emerging from their, safe house slumber or whatever it is they're doing, and see if they show up for the hearing and how Judge McAfee rules. So my friends, wherever it is you're watching us, thank you for subscribing. Thanks for liking this video. Thanks for checking out some of our links down in the description. I'd invite you to go and sign up for another Lodge event activity. We have an unboxing happening upcoming at the Lodge. So watchyourlodge.com. The events are free, but they're only posted live for a limited amount of time. So sign up for it. That way you don't miss it at watchyourlodge.com. If you want the PDFs, those are available at robertgovea.com, and you can sign up for the newsletter there as well. And we'll look forward to seeing you right back here on the next one. All right, my friends. Now, we've got some SCOTUS updates to attend to. Now, we went through this full thing this morning, but we're going to hit the highlights because it was that good. 9-0 opinion. Could that be incoming? It was a very good day for Donald Trump after all. In the Supreme Court, oral arguments on the Colorado ballot removal case. We've got the highlights. We covered the full thing when it was live here on our channel. And so if you want to watch the full thing in total, be sure to watch that full video. But we got the highlights condensed and consolidated. And a lot of what we heard today is a lot of what we've been saying here. Exactly. In fact, I thought Ketanji was asking the explicit question about why was the word president not included in the sentence if it applied to the president. We're all scratching our heads going, wow. So if Ketanji's on board, if Judge Kagan is skeptical, if Sotomayor maybe is on board, are we going to have a 9-0 opinion? We're going to see. But even MSNBC, their reaction is saying, yeah, this was pretty bad for the Colorado ballot removal litigants because what they're asking the court to do is insane. And we're going to hear what happened. I've got a bunch of the highlights, some very good clips before we get into the reaction. And of course, Donald Trump also had some reaction to this as well. Jenna Griswold was also on scene. We'll see what she looked like after she was leaving. Looked like she may have been a little unhappy with the status of the oral arguments. But starting the day off was Judge Clarence Thomas, one of the best of all time. He was asking Jason Murray about his position on examples of when a state removed a federal candidate from the ballot. Remember, this is about removing Trump off of the 2024 election ballots. Colorado said that he is allowed to be removed. The lower level court said that Trump committed an insurrection, but the 14th Amendment didn't apply. Then the Supreme Court in Colorado reversed that and said that it does. Trump cannot be on the ballot. So what Clarence Thomas is asking, he's asking the Colorado removal team, what examples do you have of other states that have removed federal presidential candidates from the list? Give me some examples, please.
States have created under their Article 1 and Article 2 powers to run elections.
But it would seem that particularly after Reconstruction and after the Compromise of 1877 and during the period of Redeemers, that you would have that kind of conflict. There were a plethora of Confederates still around. There were any number of people who would continue to either run for state offices or national offices. So it would seem that would suggest that there would at least be a few examples of national candidates being disqualified, if your reading is correct.
Well, there were certainly national candidates who were disqualified by Congress refusing to seat them.
I understand that, but that's not this case. Did states disqualify them? That's what we're talking about here. I understand Congress would not seat them.
Other than the example I gave, no. But again, Your Honor, that's not surprising because there wouldn't have been, states certainly wouldn't have the authority to remove a sitting
So what's the
federal
purpose
officer.
what was the purpose of the Section 3? The states were sending people. The concern was that the former Confederate states would continue being bad actors. And the effort was to prevent them from doing this. And you're saying that, well, this also authorized states to disqualify candidates. So what I'm asking you for, if you are right, what are the examples?
Well, Your Honor, the examples are states excluded many candidates for state office, individuals holding state offices. We have a number of published cases of states considering that.
I understand the states
controlling
state elections and state positions. What we are talking about here are national candidates. I understand. You look at Foner or Foote, Shelby Foote, or McPherson, they all talk about, of course, the conflict after the Civil War. And there were people who felt very strongly about retaliating against the South, the radical Republicans. But they did not think about authorizing the South to disqualify national candidates. And that's the argument you're making. And what I would like to know is do you have any examples of this?
Many of those historians have filed briefs in our support in this case, making the point that the idea of the 14th Amendment was that both states and the federal government would ensure rights, and that if states failed to do so, the federal government certainly would also step in. But I think the reason why there aren't examples of states doing this is an idiosyncratic one of the fact that elections worked differently back then. States have a background power under Article 2 and the 10th Amendment to run presidential elections. They didn't use that power to police ballot access until about the 1890s. And by the 1890s, everyone had received amnesty and these issues had become moot. So I don't think the history tells us.
Sort of look at Justice Thomas's question sort of from the 30,000-foot level. I mean, the whole point of the 14th Amendment was to restrict state power, right? States shall not abridge privileges and immunity. They won't deprive people of property without due process. They won't deny equal protection. Now, on the other hand, it augmented federal power under Section 5. Congress has the power to enforce it. So wouldn't that be the last place that you'd look for authorization for the states, including Confederate states, to enforce, implicitly authorized, to enforce the presidential election process? That seems to be a position that is at war with the whole thrust of the 14th Amendment and very ahistorical.
Indeed, John Roberts. So nice exchange between those two. We're always concerned about John Roberts because he's a little bit squishy on some issues. But the breakdown is, what was the basis of all of this? What were we trying to do? We didn't want the states to have more unruly power, right? Like, we just got done with a civil war. We kind of wanted to give the feds a little bit more authority, make sure the 14th Amendment, the Reconstruction Amendments, all just kind of synced up all the states. And so you're saying that as a result of that, which gave the feds a lot more power and kind of mandated that, you know, we're all under these Reconstruction rules now, like, game's over, this is the new set, this is the new, you know, mom's back home, this is the new game. You're saying that in that framework, you also gave one single state the right to disqualify, again, a federal president. Like, okay, okay, you say that, okay. And did anybody do it? No? Okay. So it just feels like it's out of alignment. Roberts is pulling that in. And Clarence Thomas, of course, hit that mark as well. Now, Gorsuch asked a very good question that basically stumped the other side. And this is the Colorado litigant who is trying to make this argument. But the question is about whether or not the 14th Amendment is self-executing. So when something happens, does Congress have to pass legislation? Do you have to have a trial to find someone's an insurrectionist? Or does it just happen? Because what they're arguing in Colorado is that it just happened. It's self-executing, because they need that to be the argument, because Congress didn't do anything else. They actually acquitted Trump of insurrection in the Senate. Right? So there was no legislation that was passed to enable all of this to happen. They just said after January 6th, Trump is now an insurrection. And I guess, right, the question is, what happens then? If he's an insurrectionist and he's now disqualified from office, what happens to the people who are under the president? So does he still have any power? I mean, if it's automatic and he's disqualified on January 7th, does he have any power at all to say anything to anybody? Here's Judge Gorsuch.
He speaks about disqualification from holding office. You say he is disqualified from holding office from the moment it happens.
Correct, but nevertheless...
So it operates, you say that there's no legislation necessary. I thought that was the whole theory of your case. And no procedure necessary. It happens automatically.
Well, certainly you need a procedure in order to have any remedy to enforce the disqualification, which is different.
That's a whole separate question. That's the de facto doctrine. It doesn't work here. Okay, put that aside.
Zip it.
He's disqualified from the moment. Self-executing. Done. And I would think that a person who would receive a direction from that person, the president, former president, in your view, would be free to act as he or she wishes without regard to that.
Yeah, he's disqualified.
I don't think so, because I think, again, the de facto officer doctrine would nevertheless come into play to say this is...
No, de facto, that doesn't work, Mr. Murray, because de facto officer is to ratify the conduct that's done afterwards and insulate it from judicial review. Put that aside. I'm not going to say it again. Put it aside, okay? I think Justice Alito's asking a very different question, a more pointed one, and more difficult one for you, I understand. But I think it deserves an answer. On your theory, would anything compel a lower official to obey an order from, in your view, the former president?
Because he's disqualified.
I'm imagining a situation where, for example, a former president was a president was elected and they were 25 and they were ineligible to hold office, but nevertheless they were put into that office.
We're talking about Section 3. And please don't change the hypothetical, okay?
Oh.
Please don't change the hypothetical. I know I like doing it too, but please don't do it, okay?
Well, the point I'm trying to make is
he's disqualified from the moment he committed an insurrection, whoever it is, whichever party, that happens. Boom. It happened. What would compel, and I'm not going to say it again, so just try and answer the question. If you don't have an answer, fair enough, we'll move on. What would compel a lower official to obey an order from that individual?
Because ultimately we have statutes and rules.
No. So he's going to go out, right? And Gorsuch left it alone after that. He said, well, okay, so you just say it's automatic. So like the country doesn't have a president like on January 7th? Like it's all done because it's self-executing? Right? It's obviously logically insane. And Gorsuch calls him out appropriately. We got a quick one from Kavanaugh. He says, you guys keep saying that, the states should be free to remove him because he's been charged with an insurrection. And if there's no mechanism to remove him, country's going to be subsumed in Trump's tyrannical MAGA, utopia. But can't we just charge him with insurrection? Can't we just, indict him if you think that he actually was an insurrectionist? Or do we have to have these little fake hearings where you just incorporate Liz Cheney's January 6th report into the trial record? What is the point of having the insurrection statute if we don't actually use it?
He had the opportunity to call witnesses remotely. He didn't use all of his time at trial. There was ample process here, and this is how ballot access determinations in election cases are decided all the time.
Okay. Second question. Some of the rhetoric of your position, I don't think it is your position, but some of the rhetoric of your position seems to suggest unless the states can do this, no one can prevent insurrectionists from holding federal office. But obviously Congress has enacted statutes, including one still in effect, Section 2383 of Title 18 prohibits insurrection. It's a federal criminal statute. And if you're convicted of that, it says shall be disqualified from holding any office.
There you go.
And so there is a federal statute on the books, but President Trump has not been charged with that. So what are we to make of that?
Two things, Your Honor. Section 2383 was initially enacted about he had the opportunity to call witnesses.
Great question, right? He wasn't prosecuted. Nobody charged him with anything. And he goes on to say, essentially, that the states have other power. The states can, delegate to themselves. His main argument was the states have plenary power to regulate their elections. And the judges did not buy into that at all. In fact, if the states do have all of the power to regulate those elections and just say who's on the bench or not, isn't that going to open the floodgates for this type of domino effect, right? It's the same thing we've been talking about here. One state will do it. It'll be a domino effect. It'll go down all over the country, and it will be bedlam and madness and chaos. And again, they don't really care about that because the left controls the trial lawyers, right? And the courts, many of them, and the secretaries of states, like they are in the infrastructure. So if the states can regulate the elections and just disqualify Trump, they're going to win that battle, right? That is a game that they can play. And if they have to have the American people actually vote for something, that is not a game they can win. So they're very unhappy about that, which is why they have to change the rules. Fortunately, John Roberts seems like he gets it.
If Colorado's position is upheld, surely there will be disqualification proceedings everywhere on the other side, and some of those will succeed. Some of them will have different standards of proof. Some of them will have different rules about evidence. Maybe the Senate report won't be accepted in others because it's hearsay. Maybe it's beyond a reasonable doubt, whatever. In very quick order, I would expect, although my predictions have never been correct, I would expect that a goodly number of states will say, whoever the Democratic candidate is, you're off the ballot, and others for the Republican candidate, you're off the ballot. And it'll come down to just a handful of states that are going to decide the presidential election. That's a pretty daunting consequence.
Yes.
Well, certainly, Your Honor, the fact that there are potential frivolous applications of a constitutional provision isn't a reason.
Well, no, hold on. I mean, you might think they're frivolous, but probably the people who are bringing them may not think they're frivolous. Insurrection is a broad broad term. And if there's some debate about it, I suppose that will go into the decision. And then eventually we would be deciding whether there was an insurrection when one president did something as opposed to when somebody else did something else.
Yep, you nailed it, John Roberts. That's exactly what they're asking you to do. They want the courts to handle all this stuff. And every state becomes its own, I guess, like little country where they just get to decide who's on the ballot and who's not. And the courts don't want to dig into that, right? And I think this was a mistake that their side made when they were going through these arguments. They kept going back to the trial. They kept saying, well, in this case, Trump had ample opportunity. He had ample process and insurrection. It's not going to, we don't really care about that, man. We care about the 14th Amendment and about what this is going to do to the entire process throughout the country moving forward. Like, the court has to deal with the rest of the country. And they kept bringing it back to just Trump, right? They're so deluded and fixated on the man that they can't even think about the next consequences. They can't see 3 inches in front of their face. It's going to cause the country to fall apart. And thank God we got the Supreme Court. Apparently has some sense. Now, Ketanji was also asking some amazing questions. So was Judge Kagan. We're like, what the heck? The only one was Sotomayor, who was kind of a little bit waffly. We'll see if she comes around. But here's Ketanji. She says, we're arguing about whether the 14th Amendment applies to the president in the first place. Remember that Judge Sarah B. Wallace in Colorado said that it did not. Said, yes, Trump technically committed an insurrection. There was an insurrection. He engaged in it, said stuff, blah, blah, blah. But the 14th Amendment didn't apply to him because it says senators, representatives, other people. And it skips over president or vice president. And then it says all other civil offices. And they say that the president is included in the other civil offices. But it doesn't make sense because it feels like it's leaving like the biggest position out. And that's what we've been saying here for months. Read it. Look. Felt like a broken record, for crying out loud. So about jumped out of our seat when we heard this one.
From rising again in the context of these sort of local elections as opposed to focusing on the presidency.
Well, 2 points on that, Justice Jackson. First is that, as I discussed earlier, there isn't the same history of states regulating ballot access at this time. So ballot access rules to restrict presidential candidates wouldn't have existed. They wouldn't have been raised one way or another.
Right, but I'm not making a distinction between ballot access and anything else.
Understood, but the more broad point I want to make is that what is very clear from the history is that the framers were concerned about charismatic rebels who might rise through the ranks up to and including the presidency of the United States.
But then why didn't they put the word president in the very enumerated list in Section 3? The thing that really is troubling to me is I totally understand your argument, but they were listing people that were barred, and president is not there. And so I guess that just makes me worry that maybe they weren't focusing on the president. And, for example, the fact that electors of vice president and president are there suggests that really what they thought was, if we're worried about the charismatic person, we're going to bar insurrectionist electors, and therefore that person is never going to rise.
Bingo. Bingo. That is exactly right. From Judge Ketanji. Wow. Yeah. Nailed it, right? And that's exactly the proper analysis of that thing. Yes, it's the electors, and you can see it in the text. Just follow the sequence of the writing. And she's a left judge, right? And so we're going, okay, this is looking pretty good here. Pretty nice, because it's exactly right. And remember, she's a criminal defense attorney, and we kind of live and die by those statutes. Like, what does that say? He was not there. This is here. He was not there. He was not doing that thing. So she's really, combing through that. And if she joins in the majority in reversing this, and she brings Kagan over, we'll see. Kagan's coming up next. Let's see.
This came up in the debates in Congress over Section 3, where Reverdy Johnson said, why haven't you included president and vice president in the language? And Senator Morrill responds, we have. Look at the language, any office under the United States.
Yes, but doesn't that at least suggest ambiguity? And this sort of ties into Justice Kavanaugh's point. In other words, we had a person right there at the time saying what I'm saying. The language here doesn't seem to include president. Why is that? And so if there's an ambiguity, why would we construe it to, as Justice Kavanaugh pointed out, against democracy?
Well, Reverdy Johnson came back and agreed with that reading. Any office is clear. The Constitution says about 20 times.
No, I'm not going to that. So let me just say, so your point is that there's no ambiguity with having a list and not having president in it, with having a history that suggests that they were really focused on local concerns in the South, with this.
All right, so good exchange there. Okay, if it meant president, it should say president. It's pretty obvious. And it's not really debatable. It's about senators. They were thinking about presidents because they talked about the electors of the president and the vice president, but they didn't mention the president specifically. And even Judge Kagan is in on this, okay? Judge Kagan, also on the left, very on the left, says the question is about why should one state be allowed to dictate how the entire country goes because they disqualify somebody. And the idea is, remember, this is already happening. Colorado disqualified Trump. Shenna Bellows from Maine used this legal concept called collateral estoppel, issue preclusion, to say that is essentially binding on Maine because they don't want to relitigate everything, full faith and credit between the courts and all that stuff. And so it transfers over to Maine and she just enters it, doesn't even need a hearing. So one state causes the domino effect, and eventually the whole country now splits apart because of these people just trying to keep Trump off the ballot. Here's Judge Kagan.
Most boldly, I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. In other words, this question of whether a former president is disqualified for insurrection to be president again is, just say it. It sounds awfully national to me. So whatever means there are to enforce it would suggest that they have to be federal, national means. Why does, if you weren't from Colorado and you were from Wisconsin or you were from Michigan, and it really, what the Michigan Secretary of State did is going to make the difference between, whether candidate A is elected or candidate B is elected. I mean, that seems quite extraordinary, doesn't it?
Yes.
No, Your Honor, because
Yes,
ultimately
it
it's this court that's going to decide that question of federal constitutional eligibility and settle the issue for the nation. And certainly it's not unusual that questions of national importance come up.
Well, I suppose this court would be saying something along the lines of that a state has the power to do it. But I guess I was asking you to go a little bit further and saying, why should that be the right rule? Why should a single state have the ability to make this determination, not only for their own citizens, but for the rest of the nation?
Yeah.
Because Article 2 gives them the power to appoint their own electors as they see fit. But if they're going to use a federal constitutional qualification as a ballot access determinant, then it's creating a federal constitutional question that then this court decides, and other courts, other states, if this court affirms the decision below, determining that President Trump is ineligible to be president, other states would still have to determine what effect that would have on their own state's law and state procedure.
Well, I mean, if we affirmed and we said he was ineligible to be president, yes, maybe some states would say, well, we're going to keep him on the ballot anyway. But I mean, really, it's going to have, as Justice Kagan said, the effect of Colorado deciding. And it's true. I just want to push back a little bit on, well, it's a national thing because this court will decide it. You say that we have to review Colorado's factual record with clear error as the standard of review. So we would be stuck. The first mover state here, Colorado, we're stuck with that record.
Okay, so she's talking about what can the court do to the lower court's ruling? You've heard of the phrase de novo, meaning the court can just look at the whole thing brand new, like with a fresh pair of glasses, like it's all fresh. Or is that not the right standard? He's saying, oh no, you can't, we don't want you to reconsider and look at the Colorado lower level court. You have to only review the record for clear error, meaning you can't change it unless you see something that was clearly erroneous that was done by the court. Otherwise, you got to let it stand. And so Amy Coney Barrett's saying, hey, if that's the case, then we just have to, you say we can decide this, but we can't decide it because you're saying the constitutional standard is clear error because the states can do whatever they want. So you just said we could fix it, but now we can't fix it. So what is it?
And, I don't want to get into whether the record, maybe the record is great, But what if the record wasn't? I mean, what if it wasn't a fulsome record? What if, the hearsay rules are, one-offs? Or what if this is just made by the Secretary of State without much process at all?
Like in
How do
Maine.
we review those factual findings?
Nailed
Why
it.
should clear error review apply? And doesn't that just kind of buckle back into this point that Justice Kagan was making, that we made with Mr. Mitchell too, that it just doesn't seem like a state call?
3 points, Your Honor. The first is that ordinarily, of course, this court reviews factual findings for clear error, but President Trump made the point in his reply brief that sometimes on constitutional questions that require a uniform resolution, this court can do something more like a Bose Corp style independent review of the factual record. And we would have no objection to that, given that the record here, really the facts that are disputed here are incredibly narrow. The essence of our case is President Trump's own statements that he made in public view for all to see.
But then that's saying that in this context, which is very high stakes, if we review the facts essentially de novo, you want us all to just watch the video of the ellipse and then make a decision without any deference to or guidance from lower court fact-finding? That's unusual.
Yeah.
Well, ultimately, President Trump himself urges this court to decide the merits of his eligibility on the factual record here at page 2 of his brief. He's never at any point in this proceeding suggested there was something else that needed to be in the factual record, any other witnesses that he wanted to call to present his case. And again, the essence of our case is his own statements, and in particular, his own videotaped statements on the ellipse.
A lot of this was, I think, a mistake because the court is not going to want to do this for every case that lands on their desk. And they're going to want to try to figure out a framework to let the lower level courts, okay, if they're saying, okay, yeah, actually states can remove people from the ballot, what are the rules? Like, how does it all work? Like, we know age 35, you're not on there. Not a natural, okay, not on there. Got it. Third term, not on there. But how does it work for insurrection? And he's saying, well, kind of the courts can decide. And then he goes back to Trump's case. But they're not asking about Trump's case. They're asking about the rules to decide whether or not they should even do something like this in the first place. And he just goes right back to Trump.
Mr. Murray, just to circle back to, I'm sorry to interrupt, but
yeah, Gorsuch cut him off. He cut him off.
Left it, wanted to circle back to where Justice Kagan was. Do you agree that the state's powers here over its ballot for a federal officer election have to come from some constitutional authority?
Members of this court have disagreed about that.
I'm asking you.
The majority of this court has said that those powers come from Article 2, but we think that the result is the same whether the court locates it in Article 2 or in a reserved power under the 10th Amendment.
But you accept that this court has held. You're not contesting this or asking us to revisit that decision in Thornton or term limits or whatever you want to call it, that it has to come from some federal constitutional authority.
All right. So digging it back into, he says the state has plenary power to just basically run however they want, right? And qualify people or disqualify people. So it was not good for their side. It was good for America because this was logical and reasonable. From the very beginning, this idea that a single state could just declare an insurrection with a 5-day trial with no process really at all, and then throw them off the ballot and that would stand was insane. But a lot of people were saying that this was a great way to save American democracy. A lot of history professors, a lot of MSNBC contributors, all these people all over the mainstream media, all saying this is a historic case of importance to save America, democracy, and all stuff. And they got obliterated, right? Their arguments are bad. Their logic is bad. They are blinded by their demented TDS. And here is what they sounded like on MSNBC.
Andrew, let me ask you first, because it seemed to us in listening to this so closely for the last 2 hours, 19 minutes or so, that there was broad agreement across the usual political division lines that there was a lot of ambiguity in this process and that ambiguity would favor keeping the candidate, Donald Trump, on the ballot.
I agree with you. My takeaway from this is you're counting the votes. Remember, Justice O'Connor famously said when she was asked what's it like to be on the Supreme Court, it's about counting to 5. Here, there is clearly, I think, 5
Definitely
votes,
5.
if not 9 votes,
wow.
that are going to reverse this case.
Wow.
The point that you made about ambiguity was raised by various justices, meaning that if it's not clear, shouldn't that sort of favor having somebody being allowed to run and thus our ability to vote for that person? There was a lot of concern about having a state have the power to interfere with a federal election. It's not a state interfering with a state election. It's should they really be able to weigh in on this? And then there was an interesting sort of across, as your point, across different justices, Ketanji Brown Jackson, Chief Justice Roberts, Justice Thomas, who is very active in this oral argument, talking about the history of this amendment, talking about how it really dealt with the Confederacy and the concern about Confederates burrowing in to Confederate states and sort of influencing federal elections.
All right, so they're all pretty muted these days. Yeah, a lot of the tonality, they're actually calling it accurately on the reaction there. But here is another bad reaction from MSNBC. This was a short one from Neil Katyal. And here is what that looks like from MSNBC. Here's a short one. He says, yeah, it's pretty bad.
I've watched over 400 Supreme Court arguments. I've done 50 myself. I would tell you this argument did not go well for the Trump challengers, and that's to put it mildly. I probably have some other adjectives that I won't say on air.
Oh, he mad, isn't he? He mad. So yeah, he probably has some other adjectives that he doesn't want to split in there. So we know what you're feeling, man. We know. I mean, I don't empathize with you, but it looks like you're pretty upset. We can see that. So not happy with what happened there. Other adjectives for how it worked. Here's Jenna Griswold, who was walking out of court. This came over from Laura Loomer on X, at Laura Loomer. She says that somebody was there. They were asking Jenna Griswold about her funding from George Soros.
Secretary of State Griswold, how much did Soros pay you to kick Trump off the ballot?
Oh, it's Crazy Eyes.
Why do you take Soros donations? How much did Soros pay you?
She didn't look like that. That was the look of death right there. Did you see that? Look of death right there. I'm going to have you murdered and your whole family. Look at those eyes, man. She will do it. She'll do it. If Trump wins when Trump wins, someone better keep an eye on her. Okay. When Trump wins, someone better keep a tab on her. I can feel her like putting the face paint on. You know what I'm saying? Like the Rambo hat on, like the face paint, listening to something like in a cabin in the woods somewhere. That could go bad like that. I can just envision it.
Soros pay you.
All right, so that was the scene out there. All right, so that's a little clip from Laura Loomer and her team. So shout out to Laura Loomer and what's going on over there. Now, here's Donald Trump. Trump came out. He had some reaction to this. He spoke immediately after the Supreme Court had their oral arguments. He said he listened in. Let's listen to the former president. Had a good day in court. Let's see. All right, audio's a little low. Let me boost that up for us.
More election interference by the Democrats. That's what they're doing. The good news is we're leading. I don't even know if we have anymore. I'm not sure that we even have a Republican candidate, somebody running, but not making any impact. So as you know, we won Iowa, we won New Hampshire in records, each one a record. We think we're going to do very well. I'm heading out right now to Nevada for the caucus and the caucuses, and I think we're going to do very well there. All polls indicate we're in the 90s, maybe more than the 90s. We certainly did well in a primary that didn't matter, where they voted very nicely. And we have tremendous support from the people of our country. They hate what's happening at the border. They hate what's happening just generally. We're not a respected country anymore. We're laughed at all over the world. They're laughing at us. And they hate what's happening. They hate seeing it. They love our country. They want it to come back. And we're going to do that. If you think about it.
There's an airplane now. Could there be anything else? I wonder if there's like a boat horn that's going to be coming up in this audio.
Had the results of the election been different, that would be nice. You wouldn't have the Ukrainian situation with Russia. We would not have had an attack on Israel, which was so horrible. You would not have had inflation. You wouldn't have China talking about Taiwan. you wouldn't have any of the problems that we have today.
True.
And you certainly had a broke Iran, and now you have a very rich Iran. Iran was broke when I left. They had no money to give to Hamas. They had no money to give to Hezbollah. And now they have 200 billion. Plus, as you probably know, people don't like to admit it, they certainly control Iraq. And Iraq has another 300 billion. So you have a very rich group of countries. And as you know, Iraq should have never happened. That was a balance against Iran, and we blew out the balance, and now Iran has essentially Iraq. And Iraq doesn't like saying that, but that's the way it is. And, it's a shame. The world is in tremendous danger. We're in danger of possibly a World War III, and we have a man who's absolutely
every day
the worst president in the history of our country. He can't put two sentences together. He's not going to be able to negotiate with Putin or Xi or Kim Jong-un, North Korea. Not going to be able to negotiate with anybody. All he knows how to do is drop bombs all over the place, meaningless bombs, except they kill a lot of people. It costs a lot of money. Every time you see a bomb, it's another $1 million, and it actually sets us back. We have peace through strength. This should not be happening. The Middle East is blowing up. It's blowing up. And a lot of people are being killed, and it's so unnecessary.
All right, Mr. President, thank you for that. So a good day in the Supreme Court for Donald Trump, for America, as the justices were calling out the other side for their insanity. I mean, there's absolutely a real possibility that we have a 9-0 opinion coming out, and that would be the right call. That is something that I think would show uniformity amongst the court. It would show that this type of election litigation is totally inappropriate. And I think that there might be some good carryover on this, honestly, for the immunity case. Now, you can read this both ways. This morning on our locals at watchingthewatchers.locals.com, a great question came up, which was about what happens if the Supreme Court is trying to split the baby, right? Trying to say, we're going to give Trump a 9-0 on this one, but we're going to then rule against him on immunity or something else, right? To allow those prosecutions to go forward. Say, we'll put him on the ballot, but the criminal prosecutions can go forward. And, there is some politics in the Supreme Court, obviously, because a lot of the Supreme Court's power, as we talked about this morning, comes from its legitimacy, from its credibility. And if it doesn't have any of that, it doesn't have any power. So if they do that, if they make that decision, to split that, maybe that's a political decision that is, something that can happen. But the alternative is that what the court is doing, right, is anchoring in, drawing a line in the sand to say that there is no appropriate way to allow the states to attack the executive, right? The states don't get to just decide that a president can be shackled. It's a federalism issue, right? A state's rights versus a federalism issue. And so if the states can't unilaterally remove themselves, can the states unilaterally prosecute a president, which might ultimately lead to, consequences that might jeopardize the national election, right? In other words, prosecutions are being used as swords to go attack your political opponents. And that is a key reason why we have immunity in the first place, to prevent all of that, right? So if the judges are inclined to say, we want to protect the power of the presidency against the state attacks, if they're inclined to do that here, there might be some basis that they do that in the immunity case, right? Kind of bodes well that they're thinking this way. Now, it's Donald Trump. We know that they're all going to be, insurrection fever there. And there's, Trump introduces a whole new set of variables. So we'll see how the immunity case goes. But I think this, especially if it's a 9-0 opinion, as it sounds like it might be, I think this is boding well for the power of the presidency, which is really what we're talking about. Can states disqualify either the candidate for that office or essentially the person in that office by charging them with crimes that they just decide on their own are criminal without any real federal oversight of that? Can RICO, Fani, or Alvin Bragg just decide to do those things? And then similarly, can Jack Smith do that? So we're going to be here and continuing to cover all of this. This was a historic day, my friends. You don't often hear election cases like this that are going to be this consequential for the whole country. And so we're grateful that we got to spend that time together with you here today. And there's going to be a lot more on this, right? There's going to be a ruling. We'll read it. here, cover it here. So be sure that you're subscribed, and I appreciate you hitting that like button and sharing the show with a friend or family member. A great way to share the show is to go to robertgovea.com, sign up for our daily newsletter that's right there, and then when the emails come in, you can just forward them to everyone you've ever met in your entire life, and they'll love you for it. So sign up for the newsletter, robertgovea.com. Don't forget to check out watcherlodge.com. We've got some great February events there. They are free, and they're free to join, and then they're up live for 48 hours before they go behind the wall. And so we'll look forward to seeing you there. Check it out, watcherlodge.com, and we'll see you back here on the next one. All right, my friends. Well, that is it for us on the day. And we covered some good ground, 9-0 in the Supreme Court. We'll see if that happens or not. I think it might actually be something that does. Clarke exposed more Fani lies, including their lies about their finances. And subpoena, Fani is trying to quash that subpoena. Quash that Fani, man. We do not want Fani to be successful in that because we want to hear her testify next week on the day after Valentine's Day. But now, my friends, let's hear from you. It's time to go over and see what you have to say about all of this before we head over to watchingthewatchers.locals.com, our members-only after party. Let's see who is joining us. We've got our friend Joanna O'Brien is a new shout-out supporter on the YouTubes. Welcome aboard, Joanna OB, in the house. Very nice to see you. Glad that you are joining us. What's up? Ryan Patrick's joining us. Good to see you, Ryan. Saying smash that like button. That's very good advice from Ryan. You definitely should. What's up, Ryan? Rob says that guy shot himself in the foot when he said impeachment is the only way. It's either going to be 9-0 or 8-1. I think the holdout might be Sotomayor. That was my, if it's 8-1, I would put it's Sotomayor. But I think that she's not going to want to be the lone, the one left out. I think she's going to, maybe want to join in on the majority. My only heads up on that. What's up, Rob? Thanks for that. Dark Side says, great show as always, Rob. I want to ask before just doing it, but I just started a print-on-demand shop, and I want to put it out to the community, but want to get the okay from you first. Of course. Yeah, share away, my friend. Share away. Yeah, you can tell, everybody about it, whatever you want to do. I think that we love to support, stuff that you guys are doing. We love doing that. By the way, have you checked out rubosaltshop.com? It's the amazing salt. I don't know what kind of salt you have, but rubosaltshop.com is great. So check that out. See, like that. What's up, Darkside? We got Red One says, hey, 5 membos are coming in courtesy of Red One. Paul Pena is here. What's up, Paul? K Tay, Lily S, Baked Alaska's in the house. Lisa's in the house. Very good to see you. Welcome aboard, Red One. Thank you for bringing in 5 of our newest membos. And new membos, you can grab the Telegram link. It is a members-only link where we have our after party. If you go over to the community tab section on YouTube, scroll down a few months back, grab the private link. We'll see you there. Red One says, Wade is a liar and a fanny hole. All right, we got this one from Tony Hay. Anita's coming in. 5 new membos from Tony Hake. Bring it in. Anita, Ulsterman. We got Brandy Coffees here. Bill L. and Grifter Wannabes in the house. Well, welcome aboard. And thank you, Tony Hay, for bringing in our 5 newest membos. Hey, America First Legal is suing Maricopa County for election irregularities. That's good news. Bill Onesie Twosie Gates. Gosh. And America First Legal. They're doing some really good work. So shout out to our friends at America First Legal. They're doing some fun stuff over there. Hey, what's up? Knox Bierman says, happy Thursday, all. Here's a quote. Their office is full of dum-dums. Lines like that make me laugh out loud, Rob. Thanks. Well, it's true. I don't know what else to call them. Bunch of dum-dums in there. It's true. Playing hooky. 5 membos coming in. Schechter Dissector. Oh my gosh. Ecoms, Carol C. Isaac Space Jesus is here. We've got also Rodney's coming in, courtesy of Playing Hooky. Playing Hooky, thanks for bringing in 5 of our newest membos. And modding down the fort on top of that as well. We got this one from Rhonda. What's up, Rhonda? Rhonda is our newest supporter as well. Rhonda, very good to see you. Hey, so supporters and membos, we do member streams in the morning. We'll be back here tomorrow morning to get into stuff we can't cover here on the live. We also do Saturday streams. And we have an amazing community. That's really the best part. We got the best people. It's a lot of fun. What's up? Red One is bringing in Tupac. Tupac Shakur is a member again. Oh my gosh. Tupac's here. West Side for life. Ride or die. Felix said this one. Fani and Nathan are taking the Slick Willie Clinton Lewinsky defense. Everyone has extramarital relationships that end in divorce. They are just as morally deprived as Slick Willie Clinton and Hillary Clinton. From Felix. Yeah. Theirs didn't end in divorce. How come that didn't happen? I don't know. Does she think she's like a little Hillary Clinton or something? I don't know. Anyways, yeah, it's disgusting. Linda, what's up, Linda? 5 months as a membo. Thank you, Linda. And I appreciate you being here. We're getting close to that 9-month mark. Robs, mods, chat, high five, HOITXOX. Good to see you, Linda. High five back to you. And I appreciate you being here. Thanks for being a membo. Hey, 487 Sean says, I will say for the third time, prosecutor declines to charge Biden in the dox case due to memory loss and dementia, aired on ABC, NBC. Yeah, it's crazy. Our president is as demented as we all suspected. And apparently it's now officially in a non-prosecution document from the special counsel called Robert Hur. We'll probably read through that tomorrow. It's like a 300-page document. So we'll probably read through that tomorrow on the show. It's just as bad as we all thought. Hey, what's up? Jeremiah says Biden will not face criminal charges for mishandling his classified papers, as if we didn't see that coming. But in doing so, they admit he's old, he's mentally shot, and exposing him as unfit and them as unjust. Wow. Yeah, it's bad. Yeah, I think we'll hit that tomorrow. Red One says Fani got, oh gosh. Yeah, Fani, she got weighted, that's for sure. Rob, can you help me with some nice ethical complaint letters? I would not have some nice words for them, LOL, and I want to put some new law bits in there. Help you want to write ethical complaint letters? Sure, happy to help. Yeah, happy to help you write those. I don't know what I would add to those. I think you can probably handle it, Catherine. You're a very nice person. Do you have nice words? Just use your nice words. Dolphin Fan. Dolphin Fan is the man. Gifting 20 membos. Oh my goodness, Dolphin. What a gift today. We've got, who's coming in? Nobody's here. Texas Ditch Doctor. Toshi's here. Sassy Tech. What's up, Ray? We got Von Cobra's here. Warren Moffitt. Coco Hall. Last of the Yahoos. Mark L. Renee C. Castro Valley. Jittery Hobo's here. Calbo Dave. We got Imprimis. Rebecca J. Clyde B. Eric V. Saintly Beginnings. And Feline Fun all coming in courtesy of Dolphin Fan is the man in the house. Thank you, Dolphin. Very generous of you today. Thank you for that. Knox says, Fani is toast. Her credibility is in the toilet no matter the outcome. I would be resigning in shame, but I do not possess a big Fani. Well, yeah, that's the thing. You know, it's hard to relate to the biggest Fani in Fulton County if you're not the biggest Fani in Fulton County. You know what I'm saying? We don't really know what it's like. It's like, you know, being like, I don't know. It's wild times. Apparently she can just do whatever she wants there. It's wild. So I agree. I think that resignation would be like the smoothest thing for this. Like, she is really a big albatross around the neck of the Trump prosecutions. So there's going to be a lot of pressure on her to go, actually. Probably from the White House. Like, something like that might even happen before the hearing. Like, she might resign in lieu of the hearing or something, you know? So it becomes moot. Something happens. I wouldn't be surprised if that happened. Fred says, just a note, Tucker and the Putin interview is up on Tucker Network. Woo, from Fred. Good to see you, Fred. And that's going to be great. So I'm going to watch that tonight for sure. And we're going to watch that, or we'll probably talk about that tomorrow. Tomorrow morning on our members only stream, we'll definitely hit that one up. Thank you, Fred, for the heads up. We got Spud says, the SCOTUS coverage was better than eating cereal while watching Saturday morning cartoons in your jammies. It was great, man. I had a ton of fun with you guys. You know, it's always fun. It's like, man, it was almost surreal. I'm sitting here listening to this. I'm like, what a wild time in America this is. Like, is Trump going to be on the ballot? We're having oral arguments of this in the Supreme Court. Of all the cases that we've talked about here, it's like wild. Sandy says, this Thomas clip shows Murray can't hold up his self-executing argument if states cannot remove a sitting president for insurrection. If Trump was ineligible, as of J6, states should have the power to remove him according to the self-executing provision. Right, and that would just lead to logical contortions. And obviously, they weren't buying that, nor should they. Spud says, Chief Justice John Squishy Roberts, what a code name. He is squishy. You know, he's always just, you don't really know what's going to happen. It's like he's not real solid. Like you want someone solid. He's kind of like mush. NY says, driving home from the office, great content. Drive safely, NY. Thanks for listening, my friend. Rob says, how do we know Crazy Eyes or any other Democrat secretary won't miscount or discount the people's votes for Trump versus Biden, or overcount votes or cheat again, like in 2020? Exactly. Yeah, they're the record keepers, right? They're keeping score. Like, would you trust Jenna Griswold to keep score in a golf game against Trump? Or a checkers game? I don't know what she plays, if any, anything. But would you think that she wouldn't, like, if he goes up to go to the bathroom, do you think like she's kind of moving the pieces around or something? Don't know. This one from Pinochet says, listen to a lot of Supreme Court oral arguments via Uncivil Law. Shout out to Uncivil. Darn you YouTube lawyers. Shout out to Uncivil. Says, I don't recall hearing the justices get this contentious. Is that normal? They can. Yeah. I mean, it's normal to get contentious. I think we heard maybe a little bit more today they were a little frustrated with Murray, Jason. They definitely were, like, Gorsuch was like frustrated with him. They were frustrated with him, no doubt, because he kind of wasn't answering their questions, and he kept going back to the Trump case, which is not what they were there for. So yeah, they maybe a little bit more, but I wouldn't say anything too unusual. We got, Rob says, Congress represents the states, the people in the House, the states in the Senate. Congress impeaches and convicts or acquits. The Secretary of State has no input. But Trump's an insurrectionist, though. That's all they got. Richard is here. What's up, Richard? Thanks for sending that one in, Richard G. No question on there, but a very nice dono, and I appreciate you, Richard. Thanks for sending that. But this one has a question from Richard. Says, oh, this is interesting. The tickets Wade bought for Fani are SVC code G, meaning he used the federal government rate for personal travel. Wow. That's interesting. So maybe we have, an airline insider, someone who knows what's going on with the codes there. SVC code G, federal government discount for his vacations. What a typical scam. Thank you, Richard. That's a very fun fact. Very interesting. I'll keep an eye on that the next time we look at the tickets, which I'm sure will be soon. Hey, Jack Mack. Jack, what a very nice dono. How generous. Says Anna Membo. Says, okay, Supreme Court arguments were quite fascinating. Definitely surprises from Jackson and Kagan, no doubt. And yeah, you're right. I was surprised too. Really enjoyed Gorsuch manhandling that poor sap. Was relieved to hear them allude to implication of Anderson's argument. Trump 2024, the people will decide. Very nice, Jack. I totally agree. And I think that that's the right call. And I would say that about any Democrat candidate. Like, let the people vote. If Trump's really an insurrectionist, then the people will vote him out. But he's not. That's why they have to do this. And it's nice to hear some good, clean logic across the board from SCOTUS on something that I think is not that complicated, actually. And hopefully we get a ruling in comportment with that. So thank you, Jack. Very generous. Jack also sent this one, says, it did annoy me that the definitive qualifications like age and nationality are grouped with something that can be extremely subjective, like this insurrection nonsense. Yeah, another great synopsis, Rob. Thank you, Jack. And yeah, and I think there was that tension there, right? So Jason Murray kept trying to put it in as the other things. It's just obvious. And he kept trying, his evidence of that was Trump's own statements. Like, Trump said the thing, and that's insurrection, and therefore we don't have, it's like age. It's categorical. He's just not allowed because he said the thing. That's why it's self-executing. But then that causes this domino effect, right? All these other consequences emerge from that, and it would cause chaos and madness, practically speaking, throughout the country. So I agree. It is extremely subjective, right? Age, okay, what's the birth certificate say? Okay, are you going to be over the age by the time you take office? Yes or no? Done. For them, it is insurrection, right? They think of it just like, oh, he did it, so therefore he's gone. And for some reason, they can't, expand that moment in time to include things like due process. Great comment, Jack. Thank you for sending those in. Very nice today. We got this one from Rob. Says, any of the states who have tried and fought to try to take Trump off the ballot needs to be audited during 2024. Please sign up to be a voting commissioner or a poll watcher. think it's a good idea to get involved in the election monitoring stuff, no doubt. Jack says, hey, a new membo, courtesy of Jack. Ms. J is coming in. Welcome aboard, Ms. J, courtesy of Jack Mack, another membo in the house. Chubby says, which ellipse video do they want SCOTUS to use? Like the entire production, the entire actual speech? There's a huge, very large difference between those. Like the fake production from Liz Cheney, or some facts that actually happened on the ground? Yeah, good question. Chubby in the house. Richard says, okay, regarding Fani, she included a threat letter saying Trump wants to bring back slavery. Why inject hate speech into her motion except to stoke more animus? That's it. And we've been saying this here for a long time, that they don't have a case, okay? And the first evidence of this was with those 4 diversion deals for Sidney Powell and Jenna Ellis's, some of the masterminds of 2020. They were on the cameras all over the time, all over the place. So if they got diversion deals that were not going to have any criminal convictions, that means they've got no evidence. And didn't even need to see the rest of the file, right? We were very clear about that. And that's why this case, right? My thought at that exact moment was this is just a process punishment. They're just going to drag this thing out. And now she's playing, plan B, racism. It's all racism. So, and then this exploded. Like the case was already bad without the love affair. It was already terrible. Cora, welcome as our newest supporter. Very nice to see you, Cora. Welcome aboard. John Allen is saying, hey, Rob, shout out to K. Bean for doing the amazing job clipping for us this morning and all the time. We love K. Bean. And thank you, John. And says, and an awesome show, Rob. Thank you, John, for clipping away for us as well. Steven's in the house, says Biden is too senile to face trial, but sharp enough to run the country, says Steven. Yeah. Well, he doesn't really need to run the country. He just needs to sign the document. Someone else is running the country. BH says, how do we know that the Secretary of State doesn't cheat? We do. We do what we've done for decades. Make sure you have someone at each counting site, gather the results there, correlate the reported numbers with the SOS counts, and they better match. From BH Williams. John Allen says, today Donut mentioned a good point to me about SCOTUS no longer needs a certain majority to vote anymore. That now it only takes 1 vote to win a case. What would it take to bring back the majority rule? I'm not sure what you're referencing, John. I mean, they still have to vote by majority to decide the case. Flash says, Rob, have you seen this? Reported the special counsel on the investigation into unauthorized removal. Oh, this is the Biden stuff. No, not yet, Flash. We're going to talk about that tomorrow. But I mean, I did see it. I saw it come across, but I haven't read it yet. So no, I've not looked at it yet. But thanks for the link. That's going to be very convenient. We'll save that for tomorrow's show. Okay, so my friends, thank you for those very generous donos on this lovely Thursday, on this beautiful Supreme Court day. Good results today, I think. I think we're going to have a good outcome on that session. Let's see who's joining us on X before we go over to watchingthewatchers.locals.com for our after party. Here is Paul Minot. He says, here's a preview. Have you seen this? Here's a preview of what we'll talk about tomorrow from the Biden report. We have also considered that at trial, Mr. Biden would likely present himself to a jury, as he did during our interview him, as a sympathetic, well-meaning elderly man with poor memory. Based on our direct interactions and observations with him, he is someone for whom many jurors will want to identify reasonable doubt. It would be difficult to convince a jury that they should convict him, by then a former president well into his 80s, of a serious felony that requires a mental state of willfulness. Weird how he gets the benefit of the doubt, isn't it? But Trump doesn't on any of these things. He's just a confused old man with poor memory. That's why he took classified documents when he was not a confused old man with poor memory. Wild. Paul says, you used the word schadenfreude today. Many think there is no English equivalent. Wrong. There is an English equivalent. It's called epic ericacy. Holy moly. That's a link for word nerds. Epicaricacy. All right. We're going to have to look that one up. All right. We're short on time, so we'll look it up another day. Danny says, Jason Murray is the next anchor on CNN or MSNBC. Hey, here it is. Yeah, here's the brand new shop from Darkside. Says, just wanted to make sure. It's a brand new shop. The intention is to add about a dozen or so items each week with a bit of everything for anyone interested in checking it out. It's an Etsy store right here, Darkside Gifts. So check it out. I don't even know what's in there, but check it out. And thanks for sharing that, Darkside. I hope it works out for you well and you connect with some good customers who love your products and everybody's happier as a result. Feline says, I'm so happy for Jocelyn that she got her due recompense in the end. Let's all chant together. Hey, Fani, we'll see you next Thursday. We'll see you next Thursday on the hearing date. Okay, so my friends, those are our friends over on X. If you want to follow us on X at Rob Govea ESQ is the platform. And of course, follow the other watchers out there, follow the other friends who are out there all across the fruited plain of America. And we'll see you there. But that is going to be it for us on the day. We are going over to watchingthewatchers.locals.com for our members only after party. And we'd love to see you there. RobertGovea.com is the place to go to get the PDFs. And don't forget to check out Watcher Lodge, watcherlodge.com. This is the community calendar. We have our unboxing coming up on Saturday. So go to Watcher Lodge, click the calendar, register for that one so you can join us. It is free and it's going to be fun. I've got it right here. Can't wait to see what's inside. We also have the Building Your Survival Squad, the workshop that we just did. This is going to be up for just a little bit longer. So go over to watcherlodge.com, click this button right here. It says Survival Squad and EMP. That's the Emergency Master Plan. And you can listen to this full lecture, this full workshop, grab the template, grab the slides, and meet some other people who are also interested in sovereignty and self-development. And it's a great way to connect with people. Watcherlodge.com. Links to all those places down in the description below. But now we're going over to watchingthewatchers.locals.com for our members only after party. My beautiful friends, we would love to see you there. But before we go, this one from Steven says, if a president releases funds to our enemies, yeah, Alito also had a question about that. Can you insurrect if you give aid and comfort to your enemies like Iran? Remember that? And Jack Mack, what's up? A membo for 5 months says Biden wasn't old or senile when he stole the documents. Exactly, Jack. Exactly right. Yeah, and this confused old man thing, should Trump have I'm just confused old man. Give me a break, okay? They always get a break. Hillary Clinton was just an idiot, but Trump is a malicious danger to America. All right. So love it, Jack. Thanks for all the donos and all the love today. Appreciate you being here. My friends, we are going over to watchingthewatchers.locals.com to debrief today's show, and we'd love to see you there. But if not, well, tomorrow is a Friday, and we're going to be back here, and we're going to get into it. And we're going to see what is going on with our demented president, in courtesy of that Robert Hur report. And so we are going to be back here tomorrow. We hope to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.